Let's be clear. Count 3. 10 to serve 3, commuted to time served, balance on probation. Count 2, 5 years probation, consecutive to count 3.
Yes, sir. Yes, sir.
And count 1, 3 years to serve, commuted to time served.
Correct, sir.
Yes, sir.
Specifically, Judge, it was negotiated from the trial division for a banishment from Metro Atlanta area.
So the state finally decides to release one of the 2 defendants that actually beat the YSL RICO trial, but another defendant banned from the A? Man. If you're new, make sure y'all hit that notification bell, that like, share, comment, and subscribe. Grab a seat. We finna dig deep. What's up, YouTube family, and welcome back to the channel. I'm your host, Jay, back with another exclusive update on this YSL RICO trial. Now today, we're going to dig deep into a huge development that definitely has everybody talk. One of the defendants, SB, also known as Shannon Jackson, is finally a free man. Well, at least released from the state's custody. But before we dig deep, y'all make sure y'all subscribe to the channel, tap that notification bell so you won't miss a drop, and definitely tap that like button. Whether you're a fan of the case, the state, or all of the above, hit that like button to help the channel continue to grow. Y'all know the vibes. Grab a seat. We finna dig deep.
Mr. Jackson, as you stand before me today, you are here on 3 indictments. Indictment 22 SC 181814, Indictment 22 SC 185532, Indictment 23 SC 188183. My understanding in consultation with the state and your attorney is that we have a global resolution to all 3 cases. Is that correct?
That is correct, Your Honor.
All right, and you're going to be entering a plea of guilty to certain charges in these 3 indictments. So if you will you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
I need for you to tell me your name and spell it, please.
Shannon Jackson. SHANNON
Okay, put your hand down. Now, Mr. Jackson, the state has a series of questions to ask you. If you can, answer yes or no. If you need an explanation before giving an answer, let the court know and we will provide you with an explanation. If you need to speak to your attorney before giving an answer, let the court know and we will give you an opportunity to speak to your attorney. Do you understand?
Yes, ma'am.
All right, thank you. The state may proceed.
Thank you, Your Honor. Mr. Jackson, at this time, are you under the influence of any alcohol, drugs, or medicine that would negatively impact your ability to understand today's proceedings?
No, sir.
And how old are you?
32.
What's the farthest level of education that you've gone?
9.
Can you read, write, understand the English language?
Yes, sir.
And you're a little soft-spoken. Do you mind speaking up a little bit for Madam Court Reporter? All right. Now, do you understand that you were charged in case number 22 SC 181814 with possession of a Schedule 5 controlled substance, possession of a firearm during commission of felony, possession of a firearm by a convicted felon?
Yes, sir.
You understand the maximum possible punishment on the possession of a Schedule 5 is up to 3 years in confinement?
Yes, sir.
You understand the maximum possible punishment on possession of a firearm during commission of a felony is up to 5 years, which would have to run consecutive?
Yes, sir.
You understand the maximum possible punishment on possession of a firearm by a convicted felon is up to 10 years in confinement?
Yes, sir.
Now, you're also charged in resolving today case number 22 SC 185532, in which you were charged in count 1 with serious injury by vehicle, count 2 entering auto with intent to commit a felony, count 3 theft by taking, count 4 failure to maintain insurance. Do you understand that as to count 1, the serious injury by vehicle, you could be sentenced up to 10 years in confinement?
Yes, sir.
Do you understand that for the entering auto, the maximum possible punishment for which you could be sentenced is up to 5 years in confinement?
Yes, sir.
And do you understand for the theft by taking, based upon what the amount alleged in the indictment, that being greater than $5,000, less than $25,000, the maximum possible punishment for that offense could be up to 10 years in confinement?
Yes, sir.
And do you understand that for the failure to maintain insurance is a misdemeanor, punishable by up to 12 months in confinement?
Yes, sir.
Now,
In relation to this particular case, I believe you've been arrested on all of these offenses. Do you understand that if you enter this plea, that this also can be used in the future? It's what we call recidivist punishment, which means that if you got in trouble down the road, a court could look and see these convictions and therefore go ahead and sentence you to something greater than it normally would. Do you understand that?
Yes, sir.
You also understand there could be what we call collateral consequences to this plea. What I mean by that is that this can have a negative impact on, say, your ability to vote, your ability to have gainful employment, things of that nature.
Yes, sir.
Mr. Jackson, are you a United States citizen?
Yes, sir.
And you understand this is a negotiated plea of guilty,
Yes, sir.
which means that your attorney and I in the state have come to a global resolution. We're going to go ahead and propose that to the court, and the court can choose to accept or reject that. However, if the court chooses to reject it, it could sentence you to something greater than what is negotiated. Do you understand that?
Yes.
Now, your attorney has worked out certain cases in which, and certain counts in which you're entering a plea of no contest, as well as Alfred v. North Carolina, okay?
Yes, sir.
So I'm going to go over each of these indictments specifically as to the counts. Do you understand Alfred v. North Carolina is a situation in which you're not admitting that you are in fact guilty? However, you do recognize that it's possible a jury could convict you, and therefore you believe this is in your best interest to go ahead and enter into that. Do you understand that?
I understand.
Right. Understanding all of that, how do you wish to enter your plea?
Guilty.
And that'd be guilty as to on the 22 SC, the serious injury by vehicle, the entering auto with intent to commit felony, theft by taking and failure to maintain insurance. Is that guilty?
Yes.
As to the 22 SC 181814, which is the possession of a controlled substance, the possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon, as to counts 2 and 3. Is that under Alpha B, North Carolina?
Yes.
And then count 1, the possession of a Schedule 5 controlled substance. Is that guilty?
Yes.
And then as to 23 SC 188183, counts 1 and 2, the participation in criminal street gang, close your verdict, or what is your plea?
No contest.
And the counts 3, possession of methamphetamine with intent to distribute, and then the counts 4 through 8, the possession of prohibited items by an inmate. What is your plea?
Guilty on the Alpha.
And is that plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand you would have only a limited right to appeal this guilty plea conviction?
Yes, sir.
And do you understand that for the felonies, you would have up to 4 years from today's date is to file what we call a habeas corpus, and that's if you want to challenge the constitutionality of this plea.
Yes, sir.
And do you understand that there is one misdemeanor on here, which is a failure to maintain insurance? Do you understand that you would have up to 12 months from today's date to also file the habeas?
Yes, sir.
Judge, I'll begin with what the negotiated recommendation is on case number 22 SC 185532. That's the serious injury by vehicle. Judge, the state's recommendation on count 1 is 10 years to serve 3 years. However, that 3 years is commuted to time served. Count 2, the entering auto with intent to commit a felony, is 5 years probated to run consecutive to count 1. Count 3, theft by taking, is 5 years probation to run concurrent with count 1. And count 4, the failure to maintain insurance, is 12 months confinement commuted to time served. Judge, as to case 22 SC 181814, possession of a controlled substance, that judge recommendation is 3 years commuted to time served. As to count 2, that would have to run consecutive to count 3. So count 3 would be 10 years probation, and count 2 would be 5 years probation to run consecutive, for a total of 15 years probation.
I believe my understanding of the recommendation was that was going to be 10, the count 2 is going to be 10 to serve 3 commuted to time served balance on probation,
Yes.
as opposed to 10 years probation.
I will defer to you as you were the one actively involved in the negotiations on this one, Mr. Sharp.
Okay, so if you just go over those again for the record, for count, for 22 SC 181814. Count 1,
Is possession of controlled substance, that would be 3 years commuted to time served. Count 2 would be 10 to do 3 commuted to.
You can't do that if you're going to do count 3, because count 2, possession of a firearm during commission of a felony, is a mandatory consecutive. So you would have to have count 3, the possession of a firearm, at some period of time, to statute minimum of 1.
Okay.
So
I don't have the indictment in front of me. I think what I meant to say is count 3. Count 3 would be 10 to do 3 commuted to time served, balance probated, and count 2 would be 5 years probation consecutive.
Correct.
The difference, Your Honor, is him essentially receiving a sentence of 12 years probation versus 15 years probation. The intent is it would be 12 years probation because he's already served those 3 years.
all right, so
Jeez. Nah, I definitely want to be clear. His charges, crazy. Definitely stacked against him. Odds not in his favor. But again, you definitely got to salute to the YSL defense team, especially YSL Short. Now, all of them did show up and do their parts, but Short has definitely fought harder for any defendant than I've actually seen in this actual trial. One case after another, after another, after another. Then you turn around and beat the entire RICO case and you had to come and deal with this from the state. Now, one thing that I do want to point out and salute him on is how he's actually catching that verbiage. Don't give him any more time than he's actually already put in. Now, a lot of people say, hey, it's not a big deal from 12 to 15 years. No, it is. You've seen this actual case. You've seen this system. Those actual 3 years that you possibly could not or should not have been on probation could definitely make a difference in whether you're free or actually belong to the state. Let's dig.
let's be clear. Count 3, 10 to serve 3 commuted to time served balance on probation. Count 2, 5 years probation consecutive to count 3.
Yes, sir.
Yes, sir.
And count 1, 3 years to serve commuted to time served.
Correct, sir.
Yes, Your Honor.
You may continue.
And as to case number 23 SC 188183, as to counts 1 through 8, they all would be a concurrent 5 years to serve 2 years, if the 2 years commuted upon time served. Judge, there are specific conditions that would go with these cases. Specifically, Judge, there was a negotiated from the trial division for a banishment from Metro Atlanta area as a condition of this sentence. He is to maintain gainful employment while on probation. There be no contact or communication, either directly or indirectly, with any named co-defendant in the case number 22 SC 183572. There is to be no contact or communication directly or indirectly with any persons associated or affiliated with a criminal street gang. And there is to be no possession of a firearm on his person in any vehicle in which he occupies nor his residence. Quite frankly, just no possession of a firearm, given he would be a convicted felon. Judge, I also understand, and Mr. Sharp had approached me about concerns about being able to travel through the Atlanta airport. There would be no objection to an exception for the Atlanta airport. Judge, this is the only case that was assigned to my unit, and I believe it actually was initially with the high-profile unit, was the gang case. And so, Judge, I do want to clarify for future cases why I am consenting to a no contest on counts 1 and 2, as it's not something I typically do, as this court's aware. Judge, the reasons for that is taking into account the working relationship I've had with Mr. Sharp over the years, who reached out to me along with Ms. Bumpus to try to resolve this case. Judge, understanding that there is multiple cases here, so I did not want to run into a situation where Mr. Jackson, who's had some incidents, unfortunately, at the jail, was remaining in jail while we litigated whether or not we were going to be dealing with a no contest on this case. And that is because also in this particular case, the typical negatives of a no contest plea for the prosecution are not present. Specifically because he is already a C recidivist, this is irrelevant, frankly, whether or not we will be able to have three convictions in the future. Judge, understanding as well that the negotiated terms of a larger sentence include provisions of no criminal street gang activity, as well as the negotiation of banishment. Judge, I believe that that is a fair trade-off in taking into consideration the banishment provision. And Judge, from a factual basis as to this particular case, Judge, we are running into a situation, had this proceeded to trial, that this was in fact a shared cell. Judge, it's been in the past occasions where other individuals' contraband can in fact be found in other individual cells, as well as the fact that there was a shared cell, so there's other individuals that would have had access. And Judge, in this particular case, I have not been made aware of any cellular dump in this particular case. Had a cellular dump been done in this case, and I have been provided with that, that would have demonstrated possession or control or an intent over the narcotics or objects inside of that cell, we probably would be in a different situation. But I am not going to hold Mr. Jackson at Rice Street or ask him to be held at Rice Street while we did a cellular dump in order to ascertain that if we have a resolution that appears to be amicable to all parties. So just for future no contest cases, I want to be able to distinguish Mr. Jackson from other defendants that maybe argued were similarly situated.
All right, thank you. So will you go over the special conditions again so I can make sure I have them correct?
Yes, Your Honor. The special conditions would include banishment from the Metro Atlanta area with exceptions for the Atlanta airport. Judge, that would also include that he has to maintain gainful employment while on probation. There is to be no contact or communication, directly or indirectly, with any named co-defendant in the 22 SC 183572 indictment. There is to be no contact or communication, either directly or indirectly, with any persons associated with a criminal street gang, as well as a no possession of a firearm. I do understand it may take a little while for him to be able to sort out the interstate compact, Judge. So there's going to be a sort of a grace period, at least from the state, in relation to him being in Fulton County until he's able to go ahead and work that particulars out with probation for the interstate compact.
Now, I ain't gonna pour no sugar on it. I'm gonna actually say, I actually like this prosecutor. Now, Short is definitely, as you see, just based off of him building relationships within the actual state, within the DA's office, the courts, the judicial system. As you see, his reputation starting to speak for itself. But even with this actual prosecutor who's actually standing in over the actual charges, reading this out, what'd he say? There was not a cellular dump done. Oh, boom, that's a plus. Because imagine had they actually went through the cell phone, what information would have actually possibly came out. Number two, what'd he say? We refuse to hold him in process and hold him in custody while we go through a process. That's huge. Because had it been the other DAs that we've seen in the previous trial or the previous judge, not Judge G, Judge G would have kept him locked up, going through the process, after the process, during the process, before the process, even after the not guilty of the process, just to reprocess the process. So that, man, you definitely got to salute to that actual prosecutor. But Shaw, SB, man, angels on your side, boy, second chance. Not too many people get that. Definitely take advantage. That's deep.
Because another jurisdiction has to accept him as a probationer, correct?
That's correct.
All right. Anything else?
Nothing from the state at this time.
All right, anything from defense?
Your Honor, I would just like you to know that Mr. Jackson is 32 years of age. His father is present here in court. His father works an honest job for an honest living. His wife is also present in court, supporting him. He has 4 children. And so a lot of these past acts involve selfishness, immaturity, and I believe that Mr. Jackson, throughout this whole legal process, has come to realize how valuable life is, and we only get one. And I think he wants to make everyone proud, all the supporters proud, and the people that have been here for him proud. So I know that he knows that he has people in his corner, and we're hoping, if Your Honor accepts this plea, we're hoping that this is something that we can all look back upon and say that this had a happy ending.
All right, so I have a couple of questions regarding the banishment. It's my understanding that he's from the metropolitan Atlanta area.
He is, Your Honor.
Okay.
He's lived here his entire life.
All right. So are there special circumstances under which he would be allowed to return during the period he's banished? Did the state negotiate?
Judge, again, that was a negotiated term outside of the one.
Yeah.
I understand there are going to be times in which this court would make exceptions, such as coming back for funerals or weddings. I understand this court traditionally does not do banishment outside of accepted negotiated terms. So to the extent this court is setting exceptions, I would defer to this court.
Your Honor, I anticipate that at some point in the future, there'll be a need to return back to Atlanta. I'm not trying to violate any agreements that I have with the state. The way I thought, quite honestly, the way I envisioned this happening was if there was a specific need, Mr. Jackson would reach out to me, and then I would reach out to Mr. Sperry. I know that creates more work for all of us, but I thought that would probably be the best workaround at this time, and quite frankly, in the future, if things are going well on probation, and maybe we can revisit some of these conditions.
All right. Yes, but you have to tell us who you are for the record.
I am Ms. Jones, Officer Jones with probation DCS. Due to the fact that where he's going, if they do not accept his case, we will have to come back in front of the judge to modify the seats. I don't know that right now, and I won't know that until 7 days from today. I have spoken with my AC, so I am trying to get the situation expedited, but he won't go to the probation until Thursday.
All right, thank you. So essentially what she's saying is until the state that you are moving to accepts your probation, you will be here in Atlanta, and everybody knows that, somewhere in the metropolitan Atlanta area. Okay? 22 SC 185532. The negotiated and recommended sentence is on count 1, the defendant is to be sentenced to 10 years to serve 3 commuted to time served. Count 2, 5 years probated to serve consecutive to count 1. Count 3, 5 years probation to run concurrent to count 1. 12 months on count 4 commuted to time served. Count indictment 22 SC 181814. Count 3, 10 to serve 3 commuted to time served. Count 2, 5 years probation concurrent to count 3. Count 1, 3 years to serve commuted to time served. Indictment 23 SC 188183. On all 8 counts, 5 years to serve, 2 commuted to time served, balance on probation to run concurrent with 22 SC 185532, count 1. And also in 22 SC 181814, the sentences are to run concurrent to count 1 in 22 SC 185532. During the time of your probation, you are to maintain gainful employment. You are to have no contact with any co-defendant in 22 SC 183572. I don't want to assume, is he not related to any of those co-defendants?
Sure.
All right, okay. So the people who used to be your friends or the ones that say you used to be associated with, you can't have any contact with them. That means you don't respond to emails, texts, smoke signals, shout outs, Instagram, whatever. They're no longer people that you can have any contact with, because if you have contact with them, you run the risk of being violated on your probation and you end up in the Georgia prison system. And from my understanding, that's not the place you want to be. I understand that you were assaulted while you were at the Fulton County Jail. And unfortunately, that's no place anybody wants to be either. So the best lesson for everyone here is to stay out of the criminal justice system. At one point, when I was a judge on the Fulton County Juvenile Court bench, 88% of the people in the Georgia prison system did not have a high school diploma. So what that tells you is the best way to stay out of prison is to get a high school diploma. So you indicated you dropped out at 9th grade. You need to go back and get a GED so you can move forward in life. If someone wants to give you an opportunity, you can step up and take it, because you can check the box that I have a GED or a high school diploma. It is basically a weeding out process and basically indicates to an employer that you know how to show up and do assignments in a timely manner. That's all they're looking for. You will show up, do the assignment in a timely manner, and not cause any problems, because you've shown you can do that because you matriculated through high school. So they just want to know you're not going to be a problem, and they don't have to worry about you. And more importantly, the court didn't want to have to look back and say, I just should have sent you to jail, as opposed to going along with this negotiated plea. You're getting a second opportunity. I suggest you take full advantage of it. You're 32 years old. I can say to you, based on what I've seen, the next time you get a felony conviction, you're going to be looking at a lot of years. And nobody's going to say yes to probation under any circumstances. So the banishment will be for 5 years, because they didn't negotiate a term. So that's for 5 years, and you can come back for special occasions, and the state and your attorney can work out what those occasions are. But you cannot come back unless you have been approved to do so and notice has been given to the state and they've signed off on it. You are to not to have any firearm in your possession because you're a convicted felon. And you're not to engage in any street gang, criminal street gang activity. I assume that you know all of the co-defendants in 22 SC 183572, so you know the people that you're not to have any contact with. I always make this an issue with the state because I don't want to assume that the defendant knows these individuals.
He does not know all the individuals, but he knows who they are from going through the case.
So I would suggest that the state provides him a list of all the individuals, their known names and their street names, and any other AKAs they have out there, so there's no misunderstanding, okay? And your family members need to know that although you can have communication with them, they should not be carrying messages from any of these people that you're not to have any activity with. So, did I miss anything?
Your Honor, just one thing. If we could put on the sentencing sheet that all these sentences are to run concurrent with the sentence that Mr. Jackson has from 22 SC 183572.
Any objection from the state?
No objection.
Okay, so all the sentences from 22 SC 181814, 22 SC 185532, 23 SC 188183 are to run concurrent with 22 SC 183572. At this time, does probation need to come on record and say anything? All right. She can't hear you.
I'm sorry. Unless you want me to tell you what the short I'm going to tell Mr. Jackson, I can talk to him.
Yes, just put it all on the record about reporting.
Okay, so he will report on December 19th at 8 a.m.
So, don't be late, don't miss that appointment, because they will come back to court and ask me to issue a warrant for you failing to appear. Do you understand?
Yes, ma'am.
All right, so at this time, is there anything else from either party?
Judge, Mr. Sharp had recommended, I have no intention of leaving my office anytime soon, at least voluntarily, so Mr. Sharp and I have built up a point of trust and communication over the years. I have no problem with Mr. Sharp reaching out to me if there's any exceptions that are necessary.
And also for the record, I will waive fines and fees for these 3 cases since he's already on probation in another case.
Thank you, Your Honor.
All right, if there's nothing further, then all parties are excused.
Thank you, Your Honor.
Welcome.
Now, For SB, this is definitely the start of a new chapter. No more pending charges, no more waiting on the state's next move. And of course, being banned from Atlanta for 5 years definitely is a significant hurt, but it's clear this outcome is better than the alternative, being locked up in Fulton County or Rice Street. And let's not forget that SB's release also signals something important about the state's case. Was this just another example of overreach by the prosecution? So let's dig even deeper and talk about the man behind this actual legal victory back to back to back, attorney YSL Shard. Now, as I've said before, and I'll say it again, Shard has been an absolute powerhouse when it came to this trial. Time and time again, we've actually seen him show up and shown out when it came to his client. And this moment here is definitely no different. Now, his skill, strategy, and relentless advocacy have definitely paid off big time. And now, as you see, SB is walking free with no further charges hanging over his head, only probation. That's not just a win, that's a statement. Wait a minute. The state's some sore losers, just my personal opinion. Now, everybody that beats the state, that still ends up on probation somehow from the state, but then you turn around and ban them from the metro Atlanta area? Nah, sore losers, in my personal opinion. You can't say that you did all of this just to help this actual defendant. Y'all did that to continue implementing damage to these defendants, letting them know that y'all are in full control at any moment. Psychological warfare, we understand. So let's dig. What exactly does this mean for the rest of the trial and the other defendants? If you've been following this case from the beginning, you'll know that every turn and twist matters when it comes to this case. But ask yourself this. Is SB's release just a sign that the state's case is actually losing some of its footing? Or is the state actually just cutting ties on loose ends that they didn't have from the beginning? Either way, this moment belongs to SB, his family, and YSL Shard. Man, y'all make sure y'all jump in the comments, let me know y'all's thoughts. Did the actual judge make the right decision? SB free, Yak still locked up? Don't forget, we about to break that down next. We ain't want to run it all together. Got to definitely make that make sense, if it does. But until then, man, y'all jump in the comments, let me know y'all's thoughts. Is it good that SB is free? Did the system actually show up and show out? Or did these actual defense attorneys put the state in a position where they had no chance but to actually release them and let them out? Until next time, remember, the life you save might be your very own. In this case, again, should go to show, the greater the height, the greater the weight. Y'all subscribe to the channel if you're not subscribed. Tap that notification so you won't miss a drop. Hit that like button on your way in or on your way out. Either way, hit the like button and show some love. It's free. Until next time, remember, I'm your host, Jay. Gone.